So this new regulation coming into force in August 2022 contains 105 articles. And honestly, I see some black holes in it. First, I do believe that all the criticism about the criteria of jurisdiction for divorce have not been heard. The only thing I see about Article 3 is that probably in due consideration of the coming up Brexit, they suppress the common domicile for England and Ireland, maybe forgetting that Ireland is still in the EU. So in Ireland now it will be the criteria of common nationality, not common domicile, which is kind of strange for me, but whatever. I still think that this choice, this wide choice of jurisdiction, and the fact that you have to put your foot in the door, the first, is an obstacle to the ADR phase that we're all trying to push forward in order to alleviate the war between the spouses. So it's really a problem for practitioners when you have to take a decision to put your foot first and seize the court in emergency because you know that another court less favorable to your client may be seized. And where do you put the mediation? Because once you have started the war, no one wants to mediate anymore. So it's, for me, it's a real problem. And I don't have any solution as a practitioner. I'm not an academic, but as a practitioner, I think it makes it difficult to have an ADR phase pre-trial. I see the residual jurisdiction mechanism quite complicated to apply. I don't know, maybe we have to be patient and see how it's going to work, but I see it as quite complicated. And honestly, there's something I don't understand is the impossibility for spouses to choose the judge for the divorce, where it's possible in maintenance, winding up of matrimonial assets and parental responsibility. And I agree with Ilaria, who said previously that in the states where we have this out-of-court divorce, we are facing publicity on internet everywhere. Do your divorce for 400 euro, and people, these professionals don't care about jurisdiction. They will manage to solve the problem in order to push people to have this kind of divorce, notwithstanding the consequences in long term about the false problem, the false solution to a problem of jurisdiction. It seems to me that most of the professionals that are not versed in European law or international private law do not consider in any way the problem of jurisdiction when they choose this out-of-court divorce. I understand that now we have no problem with the out-of-court divorce with this new regulation. But what I see is that it gives to the notary in France, it is the notaries who registers this kind of divorce. You have to know that you can change the slide. Could you change the slide? Is it possible? Okay. No. Okay. So the notaries in France are paid 50 euros for one divorce. Do you really think that the notaries are going to consider jurisdiction? No. So if we cumulate the non-versed lawyers pushing their client to do this kind of divorce, and the fact that the notaries have no knowledge of international private law for most of them, this will end in who is going to check. So with this regulation in France, the notary is considered public authority. So the notary has the burden to check. But whose authority for 50 euros is going to do that? So I think this is a real problem in practice, because I don't see a lot of notaries checking this point. Still a question remains about the, it's before, no, it's after. What again? Oh, no, stop. So I also have a problem with the consequences of divorce, such as alimony, that are not included and does not allow the agreement to be accepted. We have a way to get out of that in France. In some cases, we do the out-of-court divorce, and we do two agreements that we will register in court in order to give the spouses or the parents, the spouses, a protection under international convention and European regulation. But is this, sorry. I'm sorry. So I think this is a problem that we don't have the same agreement for the circulation of the agreements in alimony and in divorce. And okay, now on parental responsibilities, it's very good that the child has to be heard, but it's not an absolute obligation. But for example, in Germany, if the child has not been heard, it's a constitutional right of the child. How is Germany going to accept to enforce an order where the child has not been heard because there's been an agreement between the parents? I remember the reaction of a family judge in France 10 years ago when I came in and I said, okay, we have an agreement. There was no out-of-court divorce at the time. We have an agreement. The mother is going back to Germany, but I want you to hear the children. And the judge looked at me and said, but the parents are in agreement. I said, yes, but for Germany, if the children have not been heard, it's a motivation to refuse enforcement of the order. So how is Germany, for example, going to accept this thing that is contrary to their own constitution? We'll see with the practice, but it seems to me a problem. And I think also that children should have the right to be heard, even if their parents are in agreement, because some children may not be in agreement with what their parents decided. This happens. The cooperation between member states is a very good point of this new regulation, but my problem is how it's going to work on a day-to-day basis. When you see the difficulties we have, some countries react very quickly and it's very easy. I just had a case with Germany where the judge in La Réunion, very far from Paris, asked for a social inquiry in Germany, was done very quickly. But some states do not react very quickly, hence making a long time to arrive to a final order because nobody answers on the other side of the line. So we'll see how it's gonna work. I think the Brussels IIter makes a big difference in the Article 82 about the placement of the child and also the cooperation between the central authorities. I was very happy to see that it's forbidden to ask one of the defendant or the plaintiff to ask for a security bond or deposit, because there's this trend coming from United States, it came from California at the first, that you cannot have a right of access in your country if you don't post a bond or give a security. And that's obviously the breach of equality between the parties. So I was very happy to see that, which is quite new. Now I have two black holes. I would like to have the point of view of the academics on that, is prorogation of jurisdiction, Article 16, only for the purpose of maintenance, about parental responsibility. I don't understand this only for the purpose of maintenance. It would have been clearer if this has been a little bit more precise, because How are we going to understand this only for the purpose of maintenance? And Article 10, parents, again, are given the choice to agree on jurisdiction before or at the time of the dispute. This is very strange, because when you look at the regulation on maintenance, you cannot make an agreement on child maintenance because they are minors, but you are allowed to make a choice of jurisdiction even at the time of the dispute. It seems to me that there's a contradiction between the different instruments. I will go through the exequatur because a lot of people have talked very well about the suppression of exequatur, and I just want to make 3 points related to international child abduction. Clearly, the makers of this regulation have understood that time is the essence, and we have more stricter rule and stricter delays to be applied. It's also interesting to see that the burden of the proof for adequate protection is vested on the left behind parent. Good. So if in France, say that in France, it's not the left behind parents who ask for return, it is the public prosecutor. Save if the left behind parent steps in the proceeding as a joint party. If he has the means, if he has the knowledge, and if he can do it. But is the public prosecutor going to ask for adequate protection? I think this is very good that it's written, because it will maybe push the left behind parent in France to step in the proceeding to bring in this proof. If you look at the book, one of the first books that was written on The Hague by Professor Beaumont and McAlevey, he, at the time, and it's a very long time ago, advised the practitioners to look for the protective laws in the state of origin in order to produce them in court to counterbalance an Article 13b defense, saying, yes, there may be causes for Article 13b, but the legislation in the country of habitual residence has all the grounds to protect the child and can do it. I'm a little bit puzzled about this suspension of enforcement of a child after the order for return has been made, because I think there is a danger there, but maybe I'm a little bit too wary about new things, but I think there's a risk that time passing and the parent, the abducting parent, resisting enforcement, then they will have grounds not to enforce the order. But I was very happy, and this will be quite the end, that you don't need, if there's a re-abduction within Europe, you don't need to have a second order of return. You can use the first order of return and don't do the proceeding again. And to end all of that, I just want to go back to what said Justice Singer, who passed away some years ago, and who was one of the first big advocate for the Hague Conference, the Hague 1980, and who advocated for years, everywhere he went, the necessity for judges to communicate. And I think if we want this regulation to work, it's not only to the lawyers, but to the judges to speak together and try to trust each other, because it's about trust. If this regulation is going to work, it's like the Hague 1980, it's also about trust. And I will go back to what Ilaria said at the beginning. If you go on Inkedat, you have a feeling that you can be outraged by some of the last orders made, who show that there is a mutual distrust of countries who signed the Hague 1980 and don't apply it, using twisted means not to apply it. Well, that's all I had to say, and thank you for hearing me.